Welcome to Ducks in a Row, the Estate Planning Guide.
Welcome to the Ducks in a Row, the Estate Planning Guide with attorney Erin Nunes, one of the managing partners at Supernut, Beneficiary, and Nunes Estate Planning and Elder Law. Erin and her team of dedicated legal professionals are helping Southeastern Massachusetts families plan for tomorrow today. I'm your host, Lisa Mosby, and I'm here with Erin to dive into wills versus trusts and what actually makes sense for your family. The team at Supernut, Beneficiary, and Nunes Estate Planning and Elder Law are local experts dedicated to turning complex legal hurdles into clear, proactive roadmaps for adults and their children. Welcome back, Erin. Great to be with you again.
You too. Thank you so much.
Today we're talking about some complicated legal items, and in the simplest of terms, what are the difference between wills and a trust in Massachusetts?
So, a will provides direction to the probate court on how you want assets that you own individually when you pass away to be dispersed after any final expenses that have been paid. Trusts don't have to go through probate. So assets that are owned by a trust, that have a trust named as a beneficiary, avoid the probate court process entirely, and the beneficiary information that you include in your trust is kept private.
And then people often hear that trusts are only for the super wealthy. What is the actual wealth threshold where a trust becomes a smarter financial move?
So that there really isn't a threshold. It's interesting that you asked that question, because the value of what you own, in my opinion, is not the determining factor on whether or not a trust is appropriate for you. It's what are your goals for those assets. So even if you have a modest size estate, your home and some money in the bank, a little bit of money in the bank, but you've been through a tough probate process in the past, and you do not want your family to have to be involved with probate court after you pass away, then a trust might be an appropriate fit for you because it's going to allow you to accomplish that goal. So whether a will suffice or a trust is more appropriate really depends on what your specific goals are for your family and for the assets that you own.
And a will must go through probate, but a trust doesn't. Can you explain the actual cost and time difference between the two?
So in Massachusetts, a kind of easy probate, if you will take anywhere between about 12 to 18 months to wrap itself up. Between court costs, publication notices, attorney fees, things like that, it's probably going to run somewhere between about $8,000 to $10,000 to go through probate. On the other hand, trusts are private. So distributions can be made earlier than they might under the probate rules. Trusts are going to be able to be wrapped up a little bit more quickly because there aren't the same timelines and deadlines that are required with the probate court process. So it allows the administration of your estate to just be much more private and happen much more smoothly than it might if you were having to, jump through the hoops that are set forth in the probate laws.
And if there is a will, the wishes of the family become a matter of public record. Does a trust offer a layer of privacy? I heard you say it's much more private, a layer of privacy that keeps the neighbors from knowing what the kids inherited or what other in laws learn of.
Absolutely. Yep. So your trust never has to be published anywhere. It doesn't get filed with the probate court. If it owns real estate, it doesn't have to be recorded at the registry of deeds. So your beneficiaries and how they're going to inherit things is all private.
So when you have beneficiary designations on your house or your bank account or those kinds of things, do they have to be in the will or are those outside of the will? And are those items equally kept private because they go directly to the beneficiaries?
Those are kept private. and they are not controlled by the will at all. So you might have a will that says, I leave everything to my spouse and then my children, for example. And you have some assets that you own individually when you pass. Those are going to go through probate and pass according to the terms of your will. But you might have 2 CDs that you specifically named grandchildren on, for instance. Those are going to pass privately directly to the grandchildren and not be subject to probate or the terms that you put in your will.
And then for blended families, that blended family dynamic, kids from prior marriages, why is the will often insufficient to ensure that everyone is actually taken care of?
So you have to be really specific in your will if you want certain people to be included. For example, if you're a married couple and you intend after both of you have passed away, let's say there's 4 kids, 2 on each side of the marriage, and you want things to go equally. You want all the children to be treated as children, not as stepchildren. If you have not specified that in the terms of your will, they're not going to be included because they're not your biological descendants. A trust can allow you to include those individuals and to treat those people as your biological descendants for the purposes of administering the trust. So you can be a lot more flexible with provisions that you include in a private trust, a revocable or an irrevocable trust, than you may want to be in a will that has to be filed in the probate court and then becomes public.
Erin, what comes to mind is my niece's family. They have 13 kids. They're a foster family, so they have a family of 5 that they chose to foster and then adopt. So even though they're adopted, they're not biological children, so they wouldn't be treated the same if it wasn't spelled out. Is that what I'm hearing you say?
Nope, that's a good thing to point out. If you are legally adopted, then you would also be included. It's stepchildren that fall outside of that definition.
Thank you for that clarity. Erin, if a family owns a vacation home, I'm going in a different direction here. If a family if a family owns a vacation home, say on the Cape or a rental property in New Bedford, why is a trust almost always recommended over a will?
Well, I think because it is going to allow someone to be in control of that property immediately. So let's think about a revocable trust, for example. If a piece of real estate is owned by a revocable trust, typically the grantor, the person who creates the trust and puts their property into it, is the trustee during their lifetime. So they're in charge of maintaining the property, renting it, collecting rental income, things like that. But if it's owned by the trust, you've named a successor trustee. So when you become incapacitated or when you pass away, that successor trustee gets to almost immediately step in and start managing the property, making sure that homeowners insurance is in place, that real estate taxes are getting paid. So that authority vests pretty quickly. Whereas if you don't have a trust and you own real estate and you pass away, no one has the legal authority to manage that property until they are appointed as the personal representative of the estate in the probate court process. And that can often take 3 to 4 months before that happens. And there could be critical things happening with the property that no one has the authority to address during that time frame.
And Erin, there's another word or another planning technique I want to talk about that can be kind of technical for folks. How does a trust provide incapacity planning? If I'm still alive but can't manage my affairs like that property, um, how does that will do anything to help my family?
So your will doesn't do anything until after you've passed away. So it doesn't matter if you've nominated somebody as the representative of your estate. None of that has any legal effect until you've passed away. So a trust can vest those powers in someone if you become incapacitated. Also, documents like a durable power of attorney or a healthcare proxy. Those are documents where you can nominate a trusted person to make medical decisions for you, to make legal and financial decisions for you if you become incapacitated.
And if I leave money to a 19-year-old via a will, they might get it all at once. How does a trust allow parents to drip feed an inheritance to ensure that it's not wasted?
So, as I've mentioned, trusts are incredibly flexible. So, each beneficiary situation, each family situation is going to be unique. So, you can structure how you leave the inheritance for your beneficiaries almost any way that you would want. So, if we're talking about a larger size estate where it might not be financially responsible to give an 18-year-old, a 21-year-old, $2 million, you can structure it so that they get a certain dollar amount per month, that they get a third at age 25, a third at 30, a third at 35. So there's so much flexibility and different options that you can build into your trust. It's so customizable so that the needs of your specific beneficiary can be met.
Aaron, I know you've been doing this a long time. The company's been around a long time. Do you have an example of a complicated trust without sharing names or too much information that you might be able to tie this all together for us? Do you have an example that you could share that could tie all of this together in a real life experience?
Sure. I had a family a couple of years ago where there was a lot of complexity. Mom and dad had done well for themselves, and they had amassed a decent sized estate. But they had beneficiaries with some complexity. One had an MS diagnosis and was receiving needs based benefits of her own, mass health, and some other government benefits. And a second beneficiary who unfortunately had some substance abuse issues. And then a third child who comparatively, was pretty stable and doing well for themselves. So the various needs of the beneficiaries were really different. So we had to make sure that each child was going to get their inheritance in a way that best fit their situation. So we were able to create a trust that provided for the disabled beneficiary with a supplemental needs trust so that she had a nest egg that she could fall back on, but it wouldn't all be exhausted on her medical costs. And then for the son who had the substance abuse issues, they didn't wanna cut him out, which I thought under the circumstances was appropriate because they hoped that he would, be in recovery at some point. So it allowed someone else to manage those assets for him and make distributions in a way that they felt was appropriate based on kind of where he was in his recovery. And then the third child, she was getting her inheritance outright. They trusted her to take that money and provide for her own family in a way that she thought was appropriate. So there were really big differences between the needs of the beneficiaries, and we really focus in our initial consultations on getting to know a family and what their goals and concerns are, and then customizing a plan to help get them where they want to be. A family's goals at the end of the day, it's the most important thing in the estate plan. It's what drives the whole plan. So that was an opportunity to really dig into what made sense for these beneficiaries and give the parents peace of mind. I mean, they were so relieved once everything had been executed, and they knew that if something happened to them tomorrow, the kids were going to be taken care of in the way that was best for them. So that for me was um, really a service that I felt proud that I was able to help bring to them.
I like that word that you used, relieved, because sometimes we get so anxious about it or in our head about it that we don't make the appointment. We don't have the initial consultation and we don't find out what our options are. And that just lingers for a long time. But the truth is, is getting the information helps. In that scenario, if the three children were not able to manage the trust, who would become in charge of that and make sure that the trust plans were all followed?
So it depends on the family. Sometimes there's another trusted family member, um, a, a sibling of the parents or a trusted friend who might step into that role. It can be a lot for an individual depending on the needs of the specific beneficiary and the overall size of the estate. So, from time to time, it may be more appropriate to have a professional serve as the trustee because they're going to, number one, likely have the means and resources to invest and hopefully grow the beneficiary's inheritance for them. But they're also going to understand the rules surrounding, needs-based benefits or things like that. So they're less likely to inadvertently overstep or make a mistake. So sometimes that professional trustee can be really, really helpful in those situations.
Here's where I want to wrap up. If a listener is sitting at home right now and is wondering, is it always a will versus trust, or do most families actually need both to be fully protected? What is your advice to them today?
I would say if they have a goal of avoiding probate, then you should have a will and a trust. So, in that type of scenario, the type of trust that we use is something called a pour over will. So, it basically says that if there are any assets that you forgot to get into your trust, so you opened a new account, 5 years after you established the trust, you forgot to put it in the trust or you have an old life insurance policy that you forgot about, or God forbid, your passing is the result of a lawsuit or medical malpractice where your estate might become entitled to a payout. You want to have that will in place that says, take those assets that have to go through probate and pour them over into my trust so that all of those assets could be administered together and under the specific rules that we've set forth for our beneficiaries.
All right, Erin, thank you so much for your insights today. And to our audience, thank you for joining us. If today's episode was helpful to you or your loved ones, please feel free to like, share, and subscribe to empower more families across Southeastern Massachusetts. Don't wait for a crisis to start your roadmap. You can find more educational tools or schedule a consultation at myfamilyestateplanning.com. As Erin and the team at Supranaut, Beneski, and Nunes say, the best time to plan is now. We'll see you at the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.